A landlord in Ohio walked into his tenant's apartment while she was at work. No notice, no emergency. He said he just wanted to check on the property. She came home, found evidence he'd been inside, and had no idea what to do. Here's what she didn't know. What that landlord did was illegal in all 50 states. And landlords are counting on you not knowing that. In this video, we're breaking down exactly what your landlord can legally do and where the law says they've gone too far. Because the rights you don't know about are the rights you can't protect. Let's start with the most common complaint tenants have: landlords showing up unannounced. Here's the rule in almost every US state. Your landlord must give you at least 24 hours notice before entering your home. In California, New York, and Florida, the law requires 24 hours in writing. In Texas, the requirement is reasonable notice, which courts have consistently interpreted as at least 24 hours. The only exceptions are genuine emergencies: a burst pipe flooding the building, a gas leak, a fire. In those situations, immediate entry is legal because the property or other tenants are at risk. But here's where landlords cross the line, and many of them know it. I just need to check on the property is not an emergency. I want to show the unit to a potential new tenant still requires 24 hours notice. I need to make repairs, notice required, even if it's repairs you requested. And the reason landlords get away with illegal entry is simple. Most tenants don't document it, don't report it, and don't know they can take action. So what can you do if your landlord enters without notice? First, document everything. Text your landlord immediately after it happens. Something like, "I came home today and noticed you had entered the unit. I want to confirm you're aware that state law requires 24 hours notice." That text is now evidence. Second, check your state's specific law. The National Housing Law Project and your state attorney general's website list your exact rights by state. Third, if it keeps happening, you may have grounds to break your lease without penalty or pursue damages in small claims court. In California, repeated illegal entry can allow you to claim up to $2,000 per violation. The second area where landlords routinely cross legal lines is security deposits. The average security deposit in the US is between 1 and 2 months' rent. On a $1,500 apartment, that's $1,500 to $3,000 sitting in your landlord's hands. And getting it back, all of it, is something millions of tenants fail to do every year. Not because they damaged anything, because they didn't know the rules. Here's what the law actually says. In most states, your landlord must return your security deposit within 14 to 30 days of you moving out. California gives landlords 21 days. New York gives 14 days. Texas gives 30 days. If they miss that deadline, even by 1 day in some states, they may forfeit their right to keep any of the deposit, regardless of damage. What can a landlord legally deduct? Damage you caused beyond normal wear and tear? A hole in the wall, yes, deductible. Carpet worn after 5 years of normal use, no, that's wear and tear, it's on the landlord. Cleaning fees, only if you left the unit significantly dirtier than when you moved in. Unpaid rent, yes, they can deduct it. What they cannot do: deduct for repainting walls that haven't been painted in years, charge for repairs to appliances already worn at move-in, deduct for anything they can't prove with documentation. Here's the move almost no tenant makes, but every tenant should. On your move-in day, before you unpack a single box, photograph every wall, every floor, every appliance, every corner. Video walkthrough is even better. Email it to your landlord that same day. Now it's time-stamped and in their inbox. If your landlord refuses to return your deposit without justification, small claims court handles these cases in every state, and many states award up to 3 times the wrongfully withheld amount as a penalty. Every tenant in the United States has a right called the implied warranty of habitability. It's not in your lease. It doesn't need to be. It exists automatically under the law of every single US state. And it means your landlord is legally required to keep your rental unit in a livable condition, regardless of what your lease says. What does livable mean legally? Running hot and cold water, working heat, particularly in winter. Structural soundness, no infestations of pests or rodents, functional electrical systems and plumbing, and in many states, working locks on all entry doors. Here's the critical point. Your landlord cannot sign away this obligation in your lease. Some leases contain clauses saying the tenant accepts the property as is. Those clauses are unenforceable in most states. So what happens when your landlord won't fix a genuine habitability problem? Step 1. Put your repair request in writing every single time. Never just call, text or email, so you have a date stamp. If they still don't act, most states give you two powerful options. Repair and deduct. Hire a licensed contractor to fix the problem and deduct the cost from your next rent payment. Most states cap this at 1 month's rent. California, New York, and several other states explicitly allow this. Rent withholding. In severe cases, you can pay rent into a court escrow account rather than to the landlord, forcing legal resolution. Both are legitimate legal remedies. Courts have awarded tenants months of rent reductions and relocation costs. When landlords willfully fail to maintain livable conditions. The last area is where things get serious, and where landlords sometimes cross a line that becomes a criminal matter. Landlord retaliation is illegal in 48 US states. If you exercise a legal right as a tenant, complaining to a housing authority, requesting repairs in writing, joining a tenant union, or withholding rent legally, and your landlord responds by raising your rent, threatening eviction, cutting off services, or harassing you, that is illegal retaliation. The law protects you. In most states, if you can show that adverse action followed within 60 to 90 days of you exercising a legal right, there's a legal presumption of retaliation. The burden shifts to the landlord to prove the action was unrelated. What landlords absolutely cannot do, ever, they cannot change your locks without a court order. This is an illegal lockout, a serious legal violation in every state. They cannot remove your belongings from the property without a court-ordered eviction. They cannot shut off your utilities, water, heat, electricity, to pressure you to leave. This is a self-help eviction and is illegal across the country. All of these actions give you grounds for immediate legal action and potentially significant monetary damages. And if a landlord wants you out legitimately, they have to go through the formal eviction process in court. That process takes weeks to months depending on your state. During that time, you have the right to remain in the property, present your case, and appeal. No landlord can physically remove you from a rental unit without a court order carried out by a law enforcement officer. You have more protection than you think. The law built it in. You just have to know it exists. Landlord-tenant law isn't complicated, but it is deliberately undertaught. Most people only find out their rights when it's too late to use them. When the deposit is already gone, when the illegal lockout has already happened, when the retaliation has already started. This channel exists to change that. Every week we break down one area of law, property, contracts, employment, consumer rights, in plain language. With no jargon, so you actually know where you stand before you need to. If this was useful, subscribe. It takes 2 seconds and it means the next time something like this comes up in your life, you'll already know what to do. And if you're renting right now, our next video covers the 5 things in every lease agreement you must read before you sign anything. I'll see you there.